Did you know that your medical treatment could be decided by someone else if you don't plan ahead? Join me as we explore how you can ensure your voice is heard and your wishes are respected, even in a situation where you are unable to communicate them for yourself. Hello folks, and welcome back to Everything Estate Planning. I'm Jim, and today we'll be discussing living wills and, spoiler alert, why lasting powers of attorney, or LPAs, might be a better option for most people. Let's take a look at what we'll be covering in today's episode. 1. What a living will is and its purpose. 2. How living wills are legally recognised in England and Wales. 3. The importance of having a living will to ensure your medical care preferences are actually respected. 4. How to ensure a living will is valid. 5. The practical steps towards creating a living will. 6. The limitations of living wills. 7. What a lasting power of attorney is and the two types that are available. 8. The advantages of health and welfare LPAs over living wills. And as always, if you're looking for something specific, we've included timestamps to help you jump straight to any section you want to watch. So without any further delay, let's get started. So what exactly is a living will? Well, a living will, also known as an advance decision, is a legal document that allows you to outline refusals for specific medical treatments in situations where you might become unable to communicate decisions yourself. This could include critical choices about life-sustaining treatments, resuscitation, and other significant medical procedures that you might encounter during serious illness or incapacity. To clarify, a living will allows you to refuse treatment, not outline general preferences for treatment. In England and Wales, living wills are legally recognised under the Mental Capacity Act of 2005. This means that if you've outlined specific treatments you wish to refuse in a living will, doctors are legally required to follow those refusals, provided the decision is valid and applicable to the situation. The Act ensures that your wishes are respected and taken into account by healthcare professionals treating you. Refusals you can make in a living will may include things like whether or not you wish to receive life-sustaining treatment like ventilators or feeding tubes, especially if you're in a state where recovery is unlikely. Decisions regarding do not resuscitate or DNR indicate whether you want to refuse efforts to revive you in the event of a cardiac or respiratory arrest. Refusals of specific medical procedures such as certain surgeries, medications, or experimental treatments that might be considered as part of your care. Creating a living will helps ensure that your medical care refusals are clear, reducing uncertainty. It's particularly important in emergencies or serious illnesses when quick decisions are needed, and your loved ones or healthcare providers need to know exactly what you do not want. Let me give you a brief example of a living will in action. Lauren is a 70-year-old with early-stage dementia. She creates a living will in which she refuses life-prolonging treatment if she becomes severely incapacitated. Now, as the years pass, her dementia worsens, and she loses the ability to make decisions for herself. Later, Lauren develops pneumonia, and the doctors consider placing her on a ventilator. However, her family provides her living will, which clearly states that she does not want life-sustaining treatments like ventilation. Under UK law, the doctors are required to follow her instructions and instead focus on providing palliative care in line with her wishes. Now, this example demonstrates that a living will can ensure your treatment preferences are followed in a situation where you can't communicate them yourself, guiding medical professionals to respect your wishes and provide appropriate care. To ensure a living will is valid in England and Wales, you need to meet the following requirements. Number 1, you must be 18 or over and have the mental capacity to make the decision. 2, the document must be specific about which treatments you want to refuse and in what circumstance. 3, it must be voluntary. You should not be pressured or coerced into making it. 4, it must be made while you have mental capacity, meaning you fully understand the implications of refusing certain treatments. 5, for life-sustaining treatments, the living will must be in writing, be signed by you, be witnessed by one other person who also signs the document. Should include a clear statement that the decision applies even if your life is at risk. Here are some practical steps you can follow to set up a living will. First, think carefully about your values and which types of medical treatment you would want to refuse in specific scenarios, particularly in life-sustaining situations. Consult your doctor to understand the implications of different medical treatments and procedures. This will help you make informed decisions about what treatments to say no to. While not always required, seeking advice from a legal professional can help ensure your living will complies with legal requirements. They can guide you through the legal implications and make sure your document is clear, precise, and legally enforceable. Draft your living will. You can use online templates or seek professional assistance to create a legally compliant and comprehensive document that accurately reflects your wishes. Include specific instructions. Be as detailed as possible when refusing specific treatments to avoid any uncertainty about your wishes. If you're including instructions to refuse life-sustaining treatment, you must include a clear statement that your decision applies even if your life is at risk. This is required for refusals of life-sustaining treatment to be legally binding. As the person making the living will, you've got to sign and date it yourself. If you're unable to sign, someone can sign on your behalf, but only in your presence and under your direction. At least one independent witness must also be present when you sign the document. The witness should not be a family member or anyone who stands to benefit from your estate to avoid potential conflicts of interest. The witness must sign and date the document after you have signed it, confirming they were present and saw you sign. Provide copies to your GP and relevant healthcare providers and close family, and anyone else who may be involved in your care. This ensures your wishes are known and can be acted upon when necessary. Finally, review and update your living will as needed, especially if your health circumstances or preferences change. Regular reviews ensure that your document remains relevant and applicable. While living wills can be useful tools in planning for future medical care, they do have some limitations that you should be aware of when considering your options. First of all, living wills primarily cover specific treatments and interventions like life-sustaining measures and resuscitation orders. They may not address all possible medical scenarios, such as day-to-day healthcare or mental health. Secondly, vague or overly broad statements can lead to confusion and misinterpretation by healthcare providers, resulting in care that may not align with your preferences. As such, the document must be clear and detailed to avoid any uncertainty about your wishes. Third, as medical science evolves, new treatments become available, and your health condition may change over time. A static document created years ago might not adequately address current medical practices or even your present health status. And finally, even with clear language, there can still be disagreements about the intent or application of your healthcare wishes. This can lead to conflicts among healthcare providers, family members, adding stress during very critical times. Let me share an example that highlights some of these limitations. Emma is a 75-year-old that creates a living will stating that she doesn't want any life-sustaining treatment if she becomes severely ill due to her chronic lung condition. Now, several years later, she's diagnosed with a severe infection that requires temporary use of a ventilator to survive. However, the doctors determined that the infection is treatable, and with short-term ventilator support, Emma could fully recover. The living will is unclear about whether she intended to refuse treatment in situations where recovery was possible. Due to this ambiguity, the medical team decided to proceed anyway with the treatment, believing it is in her best interests. This example shows that living wills can and do have limitations if they are not specific or clear enough, potentially leading to decisions that might not fully align with the person's original intentions. These limitations highlight the need for a more flexible and comprehensive approach to managing your healthcare decisions. This is where lasting powers of attorney gracefully step in. A lasting power of attorney, or LPA, is a legal document that allows you to appoint one or more individuals known as attorneys. Now, they make decisions on your behalf if you lose the capacity to do so. This ensures that someone you trust can manage your affairs and make decisions that align with your wishes and best interests when you're no longer able to do so yourself. There are two types of LPA. One is a property of financial affairs LPA, which allows your appointed attorney to manage your financial matters. Now, this includes things like bank accounts, bills, and benefit and property sales, ensuring your finances are handled responsibly and in line with your wishes. The second one is a health and welfare lasting power of attorney. Now, this type is especially relevant here as it enables your appointed attorney to make decisions that affect your daily life and overall well-being. This can include consenting to or refusing medical treatment on your behalf, deciding on your living arrangements, and ensuring your care preferences are respected in various healthcare settings. By having a health and welfare lasting power of attorney, you can ensure that your healthcare needs are met in a manner that does in actual fact reflect your values. So why might an LPA be a better option than a living will? Here are a few reasons. First, an LPA covers a broader range of decisions that can adapt to changing circumstances. Unlike a static living will, your attorney can respond to specific situations as they arise, ensuring that your care remains appropriate and effective as your needs evolve. Second, with a lasting power of attorney, there is less room for uncertainty. Your attorney can make decisions in real time based on the best information available at that particular moment. This reduces the risk of misinterpretation and ensures that your wishes are implemented accurately. Third, an LPA doesn't just cover medical decisions. It encompasses other aspects of your health and welfare, including daily care and living arrangements. This approach ensures that all areas of your well-being are addressed comprehensively. And finally, knowing that a trusted person is making decisions on your behalf can provide greater peace of mind for you and your loved one. It alleviates the burden on your family and ensures that your care is managed by someone who understands your preferences and values. Here's an example which highlights the advantages of a health and welfare lasting power of attorney. Chloe, an 80-year-old, created a living will that refuses life-sustaining treatment if she enters a vegetative state. Later, she also put a health and welfare power of attorney in place, giving her attorney the authority to make life-sustaining treatment decisions. Now, eventually, Chloe developed severe dementia, a condition not specifically mentioned in her living will. When Chloe becomes seriously ill, her daughter, Jane, who is appointed as her attorney, is consulted. Since Jane has the legal authority to make decisions in Chloe's best interest and she understands her mum's values, she decides that Chloe wouldn't want aggressive treatment, even though the living will doesn't cover this situation. This example shows the advantage of a health and welfare lasting power of attorney. It allows for more flexible, informed decisions that reflect the person's wishes, even in situations the living will might not fully address. An important point raised by this example is whether a health and welfare lasting power of attorney takes precedence over a living will. Here's how the order of priority works. If an LPA is created after a living will and gives attorneys the authority to make life-sustaining treatment decisions, the LPA will take precedence. If no such authority is granted in the LPA or the living will is created after the LPA, the living will takes precedence. For more detailed information on LPAs, including practical steps on how to set one up, be sure to check out our dedicated video, which is linked in the descriptions below. To sum up then, living wills are helpful for refusing specific medical treatments, but they have limitations, such as being narrowly focused and open to misinterpretation. On the other hand, lasting powers of attorney can offer a broader and more flexible solution for healthcare planning. By understanding the advantages of LPAs over living wills, you can make a more informed decision about which option best suits your needs for future healthcare planning. Thanks for spending some of your time with us today. If you've got any questions or comments, please share them below. We value your feedback and aim to keep delivering useful content to a broader audience. If you found this video helpful, please give that like button a friendly handshake, subscribe and hit the bell to stay updated on our latest content. Join us in the next episode where we'll learn about beneficiary designations and how they can ensure a controlled and efficient distribution of your assets. Remember, a little planning today can make a big difference tomorrow. So until next time then, stay safe, stay informed and stay tuned.